Good morning. This is the third preliminary hearing for Module 2B, Key Decision Making in Wales, and Mr Tom Poole, King's Counsel, will now explain to me what issues are outstanding before the hearings in early-ish 2024.
My lady, as you've said, this is the third preliminary hearing in Module 2B, which relates to the core political and administrative decision-making of the Welsh Government in its management of the COVID-19 pandemic. I don't propose to reintroduce the core participants or their legal representatives. There remain 9 core participants in Module 2B, and all are legally represented. We've received 4 sets of written submissions for today's hearing, and I believe that you'll be hearing from 3 separate legal representatives later this morning. We are, of course, extremely grateful to all of the core participants for having provided us with their observations and insights, and also for the brevity with which they have done so. Whilst I do not propose to address all of the points which they have raised, I hope during the course of my submissions this morning to address those which appear to us to be of the greatest significance. My lady, may I start with the list of issues for consideration in Module 2B? In August last year, the inquiry published its provisional outline of scope for Module 2B, alongside similar scopes for the associated Modules 2, 2A and 2C. Since then, your legal team has been conducting an investigation within the remit of those published documents. You directed at the last preliminary hearing that the inquiry circulate a more detailed list of issues to core participants. That list was sent on the 12th of May, and we received insightful and constructive comments from all of the core participants, for which we are very grateful. Following consideration by your ladyship and the Module 2B team, a revised list of issues was provided to core participants alongside the CTI note on the 30th of October. The list of issues attempts to frame with clarity the matters which will ultimately be addressed in your report into the matters covered by Module 2B. As was intimated at the last preliminary hearing, the inquiry has sought to coordinate the scopes of each part of Module 2 so as to ensure fairness and consistency among the 4 nations of the United Kingdom. As was predicted, our investigations have inevitably shown that the broad issues identified in the scopes differ somewhat as between the 4 nations. The timeline in Module 2B thus differs from that in Modules 2, 2A and 2C. The issues to be examined are inevitably different due to the different structures involved in decision-making in Wales, the different trajectory of the pandemic in Wales, devolution considerations, and Wales's different advisory arrangements and legislative and enforcement mechanisms. The objective throughout has been to achieve consistency across Module 2, 2A, 2B and 2C to the extent that the facts will bear, but also to acknowledge that these differences must be respected. A question has been posed by one of the core participants as to whether the list of issues will be kept under review. I want to assure all core participants that the list of issues is not closed. Our understanding of the scope increases on a daily basis, and so the possibility that further important issues will be identified remains open. However, for practical purposes, the list needs to be given some element of finality, and with that caveat, our list is now, in our view, in such a form. Lastly, on the list of issues, one core participant has advanced submissions concerning the extent to which Module 2B will cover the care sector. Of course, there will be exploration through the high-level political decision-makers of the broad reasons why care-related decisions were taken as they were. But the detailed examination of the merits of that process and the operational impact of such decisions is outside the scope of this module, and your ladyship this morning has opened a separate investigation into the care sector across the UK. My lady, may I then turn to the issue of Rule 9 requests which have been issued by the inquiry? Can I start by saying that a huge amount of work has been done since we last met, and at very considerable pace. The inquiry has worked extremely hard to ensure that it and the core participants can be ready for the public hearings scheduled in February and March next year under this most demanding of timetables. Tens of thousands of documents and exhibits have been received from material providers so far, although not all of them, of course, are relevant and disclosable. My lady, may I commend the legal team in Module 2B for their diligence and hard work in scoping, drafting and issuing so many Rule 9s, and in dealing with the array of documentation that has been received. As of this morning, the Module 2B team have issued more than 274 formal requests for evidence under Rule 9, some in conjunction with Modules 2, 2A and 2C, but the vast majority in Module 2B alone. To give a sense of the breadth and width of your inquiry's reach, Rule 9 requests have been sent to numerous Welsh Government directorates, the Office of the Secretary of State for Wales, and other public bodies in Wales, including local health boards, which played a role in or have a relevant perspective to share on the core decisions taken by the Welsh Government in its response to the pandemic in Wales. We've also sent detailed Rule 9 requests to a large number of Welsh ministers and key advisers during the pandemic, including the First Minister, Mark Drakeford, the former Minister for Health and Social Services, Vaughan Gething, the Chief Medical Officer for Wales, Sir Frank Atherton, and the Welsh Chief Scientific Advisor for Health, Dr Rob Orford. A further 82 Rule 9 requests have been made jointly with other inquiry modules, and 40 Rule 9 questionnaires have been issued to members of the Welsh Technical Advisory Group and its related subgroups. The joint requests that have been made include a very significant number of impact questionnaires that have been sent to bodies and organisations representing individuals who might be considered to have a greater risk or vulnerability. My lady, that includes groups including the bereaved, women, children and young people, ethnic groups, those suffering from health inequalities, including long COVID and mental health issues, members of the LGBTQI+ community, workers' groups and health professionals. The issue of inequalities, since this has been raised by the core participants, has been included in practically every Rule 9 request issued by Module 2B, including those in core decision-making in Wales and their advisers. My lady, the number of Rule 9 requests and the wide range of organisations, entities and people who have received such requests, although highlighting the scale of your task, provides ample reassurance that we have cast our investigative net sufficiently widely. In addition, we have accepted additional suggestions from core participants as to who should receive Rule 9 requests, and we have carefully considered each of these and acted upon those suggestions when appropriate. In fact, in their submissions for this morning's preliminary hearing, the disabled people's organisations have suggested 2 further Rule 9 recipients, both of whom the inquiry has now issued Rule 9 requests to. We are also considering the helpful suggestions received from COVID-19 Bereaved Families for Justice Cymru, and will take those forward if we consider it necessary. It goes without saying that we are very grateful to all those who have engaged with the requests and who have provided statements. Before leaving Rule 9 requests, there are 2 aspects of the Rule 9 process that have unfortunately caused some problems. First, a number of draft statements have either contained insufficient detail or did not address all of the matters raised in the Rule 9 request. So the inquiry has asked a number of witnesses to expand upon the matters raised in their draft statements. The work required to consider those draft statements and to send requests back for further detail has an obvious impact upon the workload of the inquiry and upon the process of disclosure. However, we do not consider that overall the timetable will be significantly impacted, and we are confident that the final signed statements and exhibits will be disclosed for them to be reviewed by core participants in good time ahead of the public hearings next year. Second, in respect of a number of entities and individuals, there has been a failure to respond sufficiently quickly to the Rule 9 requests, necessitating repeated extensions to deadlines. We are on top of the issue, and it is expected that all finalised statements, exhibits and disclosure will be provided by the end of this month. I wish to emphasise, however, the absolute need to comply with these final deadlines, given the diminishing time before the substantive hearings. Further requests for extensions are unlikely to be granted. My lady, may I next turn to the Welsh Government. Unsurprisingly, given the scope of this module, a significant proportion of Rule 9 requests have been made to the Welsh Government, its directorates and individuals who played key roles in its response to the pandemic. In most cases, the requests that have been made have required considerable work to be completed within demanding timescales, and I would like to acknowledge that the Welsh Government and their legal team have worked very hard to respond to the requests, and we are very grateful to them for that cooperation. There have been some delays and extensions have been sought, some with good reason. The inquiry recognises that there has been a significant volume of materials sought from the Welsh Government. This, however, has to be balanced against the fact that this is an inquiry into Welsh Government core decision-making during the pandemic. Those core participants that have expressed concerns with the disclosure from the Welsh Government can rest assured that we have been working with their team, and all outstanding disclosure was largely provided by the end of November, subject to additional Rule 9s which have recently been sent. My Lady, I would like to draw attention to two specific matters. The first concerns informal messaging, namely WhatsApps and texts. The second, notebooks. You will be aware, my lady, that the issue and content of informal communications, in particular WhatsApp and text messages, has become a prominent part of the inquiry's investigations into core decision-making by the UK government in Module 2. Those conducting this module's investigations have thus been aware for some time of the need to investigate the use of such informal messages by those involved in the Welsh Government response to the pandemic. We are very aware that messages sent by informal methods of communication between key decision makers and their advisors, discussing information, advice, and the management of the pandemic in Wales, can provide important information about and context to decisions and issues which are to be addressed in this module. We therefore welcome the submissions made by Counsel to the Welsh Government at the Module 2 preliminary hearing in June this year, when it was said that the Welsh Government intends to fulfil all such requests made of it by this inquiry for WhatsApp messages, diaries and the like, without any prior redaction. As a result of the significance of informal messaging in the way that the government business was conducted in Westminster, in our first Rule 9 to the Welsh Government in October last year, we asked the Welsh Government to explain whether there were WhatsApp groups, group chats that key decision makers used to communicate about decisions or to make decisions. The Welsh Government was also put on notice that the inquiry may request disclosure of emails, WhatsApps and texts through the course of its investigation. Similar requests and notifications were also made to other significant Welsh public bodies, including Public Health Wales and local health boards. As I have already set out, extensive individual Rule 9 requests were also compiled for individuals who worked within the Welsh Government operation, including senior scientific and medical advisors. For the avoidance of doubt, we sought not only messages in which decisions were communicated, but also messages in which matters relating to government decision-making were raised, in order that a full assessment of the basis upon which such decisions were arrived at could be undertaken. Some of the witness statements that we have received from key decision makers within the Welsh Government suggest that informal communications, such as WhatsApp messages, were used to discuss matters around the progress of the pandemic in Wales. Following discussions with the Welsh Government, the Module 2B team received its first set of WhatsApp messages in early October this year, and as of today, the inquiry has received 21 transcripts of WhatsApp group chats and 163 transcripts of individual WhatsApp or text message conversations during the pandemic, provided by a number of different individuals within the Welsh Government, including the First Minister. These transcripts have been reviewed, and a large proportion of them are currently at the material provider review stage with the Welsh Government, following which they will be made available to core participants. The Module 2B team has also issued a further Rule 9 request to the Welsh Government for a corporate statement on the use of informal messages, as well as individuals within the Welsh Government, asking for the provision of further information and an explanation where WhatsApps and text exchanged during the pandemic do not appear to have been provided to the inquiry or retained. A response to that request was received on Friday last week and is being reviewed. The inquiry is also receiving responses from individuals on a rolling basis, which will be made available for core participants once they have been through the material provider review process. Finally, on the issue of informal messaging, I would like to add that the inquiry intends to keep an open mind as to the significance of the responses and not rush to the conclusion that these messages provide the key to understanding the processes of Welsh Government decision-making during the pandemic. We will not rush to conclusions, but reach them on the basis of the evidence that the inquiry uncovers. As regards notebooks, the Welsh Government has provided us with access to over 100 contemporaneous notebooks from individuals within the Welsh Government, including ministers. The Module 2B team have been undertaking physical reviews of those notebooks to determine relevance, and the Welsh Government has confirmed that no further notebooks are available for review. A full review of the notebooks is presently underway by the inquiry, and a tranche has already been disclosed to core participants. Further tranches will continue to be provided on a rolling basis when available. If I can move next to an issue regarding data loss, which has been raised by one of the core participants. On the 2nd of August this year, we received notification from Digital Health and Care Wales of a potential data loss issue in relation to the Microsoft 365 email service, which could impact all health boards, trusts, special health authorities and primary care organisations in NHS Wales. My lady, you will not be surprised to hear that we took this issue seriously and made immediate inquiries with material providers that might have been affected. We understand that from all of the Rule 9 requests made in this module, only one individual has been impacted by the data loss issue, and the position is explained in their witness statement. Turning then, my lady, to the issue of the general state of disclosure of documents to core participants. As of this morning, Module 2B has received 30,838 documents in total, including 58 questionnaire responses from impact organisations, 32 questionnaire responses from members of TAG and TAC, and 148 Rule 9 statements. To date, we have disclosed 12,396 documents in total to core participants, including 67 Rule 9 statements and supporting documents, which include some Module 2 statements relevant to our module, 48 questionnaire responses from impact organisations, including those jointly instructed with Modules 2, 2A and 2C, and 32 questionnaire responses from members of TAG and TAC. We will continue to make disclosure to core participants on a regular basis and hope to shortly disclose witness statements and exhibits from various Welsh ministers. The inquiry expects to have received all draft witness statements in sufficient time to enable disclosure of the vast majority of signed statements by the end of this month. The Welsh Government has been providing documents to the inquiry on a rolling basis and, subject to a few Rule 9s which have been issued recently, has confirmed that it has provided all general disclosure in response to Rule 9 requests made of it over the last 12 months. As a result, whilst some 12,396 documents have been disclosed across 42 tranches of material, Module 2B still has a significant volume of documents left to review, assess for relevance and work through before they can be disclosed to core participants. The Module 2B legal team is working swiftly to review materials which have been disclosed to it, and I'm very grateful to the material providers who are assisting with this important process and doing so at pace. There remains much to be done, and materials will continue to be made available to core participants as quickly as possible. I propose to say something next about cross-modular disclosure. The inquiry is aware that some evidence received by Module 2 and some oral evidence provided at the Module 2 public hearings is likely to be relevant to Module 2B. In order to ensure that core participants have access to Module 2 material that is relevant to Module 2B, the inquiry is conducting a cross-modular review to identify such relevant material. As a number of our core participants have been core participants and hence involved in the work of the prior modules of the inquiry, they will have had access to this material already and indeed may be well placed to assist with drawing our attention to documents which they think ought to form part of Module 2B evidence proposals in due course. The inquiry intends to disclose any material considered relevant to Module 2B to core participants and indeed has already started to do so. This will include witness statements, exhibits, and aspects of general disclosure that has been received by Module 2. We will, however, be limiting the disclosure of material to those documents that are strictly relevant, i.e., where a witness statement discusses issues relevant to Module 2B, it will be disclosed to core participants. It follows that not all of the exhibits, however, to such witness statements will be disclosed in Module 2B. They will only be disclosed if those exhibits are considered relevant to this module. My lady, the next issue on the agenda concerns preparations for the public hearings in February and March next year. My lady, may I start by addressing you briefly on the issue of timing, because I want to say something about the very considerable progress that the inquiry has already made and about the timing of the public hearings next year. We have proceeded at a remarkable pace. No inquiry with so wide a scope has ever proceeded with such speed. Having said that, the inquiry process is simply not designed to assemble every single document and person relevant to the preparation for, response to, or the impact of the COVID pandemic. That would be an impossible task, and no sensible inquiry could ever contemplate it. What we've done is to seek the witnesses and documents that you have considered are most relevant to the issues that you've decided you want to explore. This is especially so in Module 2B and the associated Modules 2, 2A and 2C, because they are concerned with high-level political and administrative decision-making. We are not inquiring into every aspect of every decision on COVID made by the Welsh Government. It is an inquiry into only such parts of the decision-making process that appear to you to really matter. But even then, my lady, I need to put the core participants on notice that it is impossible to call every witness who can give evidence of every issue covered in every paragraph of the list of issues. We have neither the time nor the resources, and I dare say the core participants and the general public would not wish it to be so. So choices will have to be made as to which witnesses will be called at the public hearings. But, my lady, there can be no doubt by the time of those hearings, sufficient material will have been secured and disclosed to core participants to enable you to be satisfied you can conduct an absolutely full and fair inquiry. As to hearing preparation, as previously announced, the hearings in Module 2B are scheduled to be held at the Mercure Cardiff North Hotel, starting on the 27th of February next year and concluding on the 14th of March. As regards the venue, work is underway to address the issues of access raised by some of the core participants, such as a daily shuttle service from the centre of Cardiff to the venue. As to the hearings themselves, ahead of the hearings, Module 2B intends to share key documents which it has prepared with core participants. It is likely that this will include a chronology of key decisions and events, details of the structures involved in Welsh Government decision-making, and the identity of key individuals involved in such decision-making. The intention of these will be that they will cover some of the uncontroversial background, allowing the hearings themselves to focus on the key controversies and issues. It is also intended that key aspects of the agreed uncontroversial background will be set out in my opening statement at the start of the public hearings. In addition, core participants will be invited to engage in the hearing preparation process, which has been adopted by the inquiry in Module 2. This will involve evidence proposals being produced and core participants being permitted to propose important documents and suggest potential lines of questioning for witnesses in connection with those evidence proposals, which will be sent to them in advance of the hearings. The intention in our module is to try and follow a regimented process, whereby a draft evidence proposal for a witness is circulated to core participants a certain period before a witness is due to give evidence, with clear indicators as to the date by which a response is expected. The same will apply to applications to contribute to questions to be asked by counsel to the inquiry, or applications to ask questions, the opportunity for both being invited simultaneously. Thus, the timescales for each witness in which a particular core participant might be interested will be clearly prescribed from the start, hopefully increasing certainty and providing a reasonable opportunity to contribute to the hearing preparation process. Precise details and timings of what we intend in this regard will continue to be provided to core participants, either as necessary or in monthly update notes issued in due course. I turn next to expert witnesses. As set out in the previous monthly update notes, Module 2B, in conjunction with Modules 2, 2A and 2C, has issued instructions to the following experts who have agreed to provide evidence to the inquiry on matters relating to Wales, which will be covered by this module. Professor Thomas Hale from the Blavatnik School of Government, University of Oxford, has reported on international data relating to the COVID-19 pandemic, in particular in analysing the effectiveness of the decision-making of the UK and each of the devolved administrations to the pandemic in comparison to other countries. This report has been disclosed to core participants in final form and was presented at Module 2's public hearing on the 11th of October. Professor Ailsa Henderson from the University of Edinburgh has reported on the political structures for devolution within the UK and mechanisms for intergovernmental decision-making between the UK government and the devolved administrations during the COVID-19 pandemic. This report has been disclosed to core participants in final form and was presented at Module 2's public hearing on the 9th of October. An expert report relating to political decision-making in the management of the pandemic in Wales has also been commissioned by Module 2B from Professor Daniel Wincott, Professor of Law and Society in the School of Law and Politics at Cardiff University. This report is currently in draft form and has been circulated to core participants for their comments, following a similar process to the finalisation of other expert reports which have been commissioned by the inquiry. The inquiry appreciates that we have set a tight deadline for core participants to provide their comments on Professor Wincott's draft report. We are grateful for their understanding and continued engagement. Expert reports of indirect relevance to the matters for consideration in Module 2B were also commissioned from Alex Thomas and Gavin Freegard. Alex Thomas from the Institute for Government has been instructed to report on the decision-making structures of the UK Government in an emergency, in particular the Cabinet Office, Cabinet Committees and the Office of the Prime Minister. And Gavin Freegard, former Programme Director and Head of Data and Transparency at the Institute for Government, has been instructed to report on the access to and the use of data by the UK Government during the COVID-19 pandemic. Reports from these two experts have been disclosed to core participants in final form. Gavin Freegard's report presented at the Module 2 public hearing on the 10th of October and Alex Thomas's report on the 13th of October. One core participant has queried whether the issue of data sharing covered by Gavin Freegard in respect of the UK Government will be covered by another expert in respect of Wales. As previously explained in our monthly update notes, the inquiry has unfortunately been unable to identify an independent expert who can address data governance issues in Wales. We have therefore issued Rule 9 requests to individuals involved with data governance within Wales so as to gather relevant evidence in this regard. This approach has also been adopted in Modules 2A and 2C. In your Ladyship's ruling of the 9th of March, your Ladyship directed the inquiry should obtain evidence from an expert or experts on the nature and degree of pre-pandemic structural racism. This ruling also makes clear that expert evidence should be obtained regarding pre-existing structural discrimination on other grounds. The following experts have been instructed, including in relation to matters within the Module 2B scope relating to Wales. Evidence from these experts has been adduced and led in Module 2. Professor James Nasru, Professor of Sociology at the University of Manchester and Deputy Director of the ESRC Centre of Dynamics and Ethnicity, and Professor Leah Bakares, Professor of Social Science and Health at King's College London, have produced a report on pre-pandemic inequalities by race and ageing, including expertise on the role of structural racism. This report has been disclosed to core participants in final form and was presented at the Module 2 public hearings on the 5th of October. Professor James Nasru is also contributing expertise on later life, this report having been disclosed to core participants in final form. Both of Professor Nasru's reports were presented at Module 2's public hearing on the 5th of October. Professor Thomas Shakespeare, Professor of Disability Research at the London School of Hygiene and Tropical Medicine, and Professor Nicholas Watson, Associate Professor of the School of Health and Wellbeing at the University of Glasgow, are contributing expertise on pre-pandemic inequalities associated with disabilities. This report has been disclosed to core participants in final form and was presented at the Module 2 public hearing on the 9th of October. Professor Leah Bakares is also providing expertise on pre-pandemic inequalities for members of the LGBTQI+ community. This report has been disclosed in final form to core participants and was presented at the Module 2 public hearing on the 9th of October. Dr. Claire Wenham, Associate Professor of Global Health Policy at the London School of Economics and Political Science, is providing expertise on pre-pandemic gender inequalities. This report has been disclosed to core participants in final form and was presented at the Module 2 public hearing on the 6th of October. Professor David Taylor Robinson, Professor of Public Health and Policy at the University of Liverpool, is providing expertise on pre-pandemic childhood inequalities. This report has been disclosed to core participants in final form and was presented at the Module 2 public hearing on the 6th of October. A further expert report has been disclosed to core participants prepared by Professor Chris Breitling, Professor of Respiratory Medicine at the University of Leicester and Chair of the NIHR Respiratory Translational Research Collaboration, and Dr. Rachel Evans in relation to long COVID. This was presented at the Module 2 public hearing on the 13th of October. The current provisional intention of Module 2B is that it will not lead further evidence from the experts who have spoken about matters of general relevance across the UK, such as Professor Breitling and Dr. Evans, or whose reports have specifically covered Module 2B in their remit, including Professor Henderson and Professor Hale and the inequalities experts, whose written and oral evidence already covers Welsh considerations. The evidence which they have provided to the inquiry remains available for consideration at the Module 2B hearings and or in the final report on Module 2B matters. Issues arising from their evidence about governmental, including intergovernmental structures, NPIs and structural inequality, and by extension inequality in political decision-making and outcomes, have been and will be canvassed at the Module 2B hearings with other witnesses. It is also likely that I will cover key aspects of this evidence in my opening statement at the hearings in February. Finally, on the issue of experts, one of the core participants has asked that experts' letters of instructions be disclosed. My lady, in my submission, providing the letters of instruction now is neither necessary nor sufficient. Firstly, it is not necessary to have such disclosure now because the core participants will have time to receive and consider the expert reports themselves. Secondly, the provision is not sufficient because the letters of instruction provide only the framework for an expert report and can say nothing, of course, about the expert's opinion. The core participants need the reports themselves in order to be able to understand what is being opined upon, and that is what we are providing. My lady, the final issue on the agenda this morning concerns Every Story Matters and impact films. Every Story Matters was formally launched on the 13th of June this year. The experiences and stories shared are helping the inquiry to build a comprehensive picture of how the pandemic affected people's lives across the UK, including in Wales. An updated web form was made available in late May, and to date, thousands of responses have been submitted. The public information campaign to make people aware of Every Story Matters has been running on radio, billboards, in the press and digital advertising. The inquiry has been working with charities and other organisations to promote Every Story Matters to seldom heard voices. Campaign activity aimed at raising awareness of Every Story Matters will take place in Wales from the 22nd of February next year and will run until the end of the Module 2B hearings. A community listening event held by members of the inquiry team took place in Wrexham in mid-November with another in Ruthin, enabling the people of North Wales to meet the team and find out in person how they can share their story. An impact film will be shown on the first day of the public hearings for Module 2B to set the tone for subsequent proceedings, grounding them in the lived experience of individuals living in Wales who suffered and continue to suffer hardship and loss as a result of the pandemic. The video will be played publicly at the substantive hearings of this module in February next year. My lady, I hope what I've said brings those with an interest in Module 2B up to speed with the progress which has been made since the last preliminary hearing and sets out a roadmap as to how we intend to progress matters going forward up to the point of our public hearings in Wales next year. May I again, on behalf of the Module 2B team, offer our thanks for the helpful contributions made by the core participants to this hearing and the continued contribution of core participants and other material providers to the work of this module. It is very much appreciated. It is also necessary. May I finally pay tribute to the legal team with whom I am working. The Welsh public can rest assured that they are doing all they can to deliver these hearings to the very best of their ability and with the fullest and deepest investigation into the management of the pandemic in Wales that we can achieve. My lady, that concludes my opening submissions in relation to the important matters raised in written submissions and in relation to the practicalities of this module. May I lastly just seek permission to publish the core participants' submissions and the CTI note. And I understand you are going to hear first from Miss Heaven on behalf of the COVID-19 Bereaved Families for Justice, Cymru.
Thank you very much, Mr. Poole, and I give permission for the publication of the submissions and the note. Miss Heaven.
Good morning, my lady. Thank you. As you know, I represent the COVID-19 Bereaved Families for Justice, Cymru, and it will come as no surprise to the inquiry that the majority of my submissions this morning will relate to the linked issues of delayed disclosure and what appears to be the deletion or loss by the Welsh Government of highly relevant communications between members of the Welsh Government and its advisers, including but not necessarily limited to WhatsApp messages. Time permitting, I'll briefly touch upon a number of other issues. But can I start by saying that these submissions do not in any way call into question the efforts the inquiry has made and is continuing to make on behalf of the Welsh bereaved. Now, the first issue, as I've indicated, relates to delayed disclosure by the Welsh Government to this inquiry in Module 2B. And as Milady knows, this hearing was scheduled to take place on the 16th of November. CTI's written update for this hearing was prepared now some 6 weeks ago on the 30th of October 2023. And it's important to note that at that stage, so in other words at the end of October, core participants were being told that the Welsh Government had delayed in the provision of certain responses to your Rule 9 requests, and that your CTI's level of concern was such that core participants were being told that this delayed disclosure has the potential to disrupt the inquiry's process unless they are quickly resolved. Now, we learned today from your counsel to the inquiry, Mr Poole KC, that certain draft statements contained insufficient detail or did not address all the matters raised in the Rule 9 requests, and that there were failures to respond sufficiently quickly, necessitating repeated requests for extension of deadlines. COVID-19 Bereaved Families for Justice Cymru are extremely disappointed to learn today that some of the delays and extensions relate to the Welsh Government. Now, it is important to note that the Welsh Government, in their written response to your counsel to the inquiry's note of 30th of October, was unfortunately not in any way apologetic for these delays. But apparently, certainly at least from the perspective of the Welsh bereaved, it seemed to be rather defensive, pointing out what had been disclosed rather than being clear on what had not been disclosed. Certainly in that response, there appeared to be no acknowledgement by the Welsh Government of the impact of delayed disclosure on the ability of core participants to effectively participate in this inquiry. We are now some 6 weeks ahead of that CTI note of the end of October and some 11 weeks before the commencement of Module 2C, and core participants still do not have anywhere near full disclosure from the Welsh Government. Milady, of course, those whom I represent fully understand that your inquiry has very important processes that must be adhered to before you can disclose any material. So to be clear, core participants still do not have Module 2B witness statements from many significant witnesses, to name a few: First Minister for Wales Mark Drakeford, Vaughan Gething and Eluned Morgan. So the bereaved non-state core participants are facing a situation in Module 2B not dissimilar to that faced in Module 1, where the Welsh Government also delayed in providing certain key disclosure right up until the last minute, which delayed onward disclosure to core participants by the inquiry. Now, the Welsh bereaved are understandably asking, how could this have happened? Because, as you know, my lady, in the early days of this inquiry, the Cymru Group, the UK Government, the Senedd and this inquiry received repeated assurances from the First Minister for Wales, Mark Drakeford, and the Welsh Government that they were committed to fully engaging with this inquiry. And these assurances were repeated after Module 1. And I do just want to repeat again what Mr Drakeford said to the Right Honourable Boris Johnson MP when he was Prime Minister and when he announced the inquiry. So Mr Drakeford said the following: "I would invite you to agree that all public bodies engaging with the inquiry are expected to consider themselves under a duty of candour. That duty should drive their culture of engagement with the inquiry and should lead to prompt and comprehensive disclosure of all relevant material to the inquiry. A duty of candour should also guide the way the public body witnesses should approach the inquiry." So the COVID-19 Bereaved Families for Justice Cymru asked the Welsh Government to explain, where is this prompt disclosure that they promised way back in November 2021? With that in mind, can I now turn to the issue of non-disclosure and deletion or loss of other forms of informal communication, including but not necessarily limited to WhatsApp messages. Now, as we know, with a few notable exceptions, significant volumes of WhatsApp messages were retained and disclosed to this inquiry by the UK Government in Module 2. These contemporaneous notes and messages between civil servants, special advisors, scientists and politicians have played a key role in illuminating how and why political and administrative decisions were made by the UK Government. It was therefore very surprising and indeed concerning to learn from your Counsel for the Inquiry's update note of the 30th of October that only very limited WhatsApp messages and text messages had been disclosed to the inquiry by the Welsh Government as at that date, and that several individual witnesses within the Welsh Government had apparently deleted or simply lost WhatsApp messages from the relevant period. Lady, can I start by making a request for a bit more clarity from the inquiry as to what exactly the inquiry have requested of the Welsh Government and their advisers, and whether the request for disclosure extends to all forms of informal communications, to include not just WhatsApp, but other platforms such as Signal, Telegram, Discord, MS Teams Chat, iMessage, Facebook Messenger. This appears to have been the case in respect of the requests to the Scottish Government, which were outlined by your Counsel for the Inquiry in the recent Module 2A preliminary hearing, and we are assuming that the same rigorous approach has been adopted in relation to Wales. I now turn to the Welsh Government's written response to this inquiry on the WhatsApp non-disclosure issue. This is the written response of 16th of November. Now, the Welsh Government in their defence state that searching for WhatsApp text material is, in their words, time-consuming, demanding of resources and technically problematic, and the word complex is also used. Lady, the COVID-19 Bereaved Families for Justice Cymru were staggered by this response. The Welsh Government have had more than sufficient time to find, preserve and disclose these informal communications in a timely fashion. The inquiry needs no reminding of the timelines, but the key dates are placed on record for the avoidance of any doubt. Counsel for the Inquiry's October update noted that the Welsh Government committed to providing WhatsApps and related material in June 2023. However, in fairness to the inquiry, the expectation that this material would be disclosable arose much earlier, and as you well know, my lady, on the 2022, you wrote a letter to the Director General of Propriety and Ethics at the Cabinet Office on record retention, and you clearly stated that, quote, "I would ask that each department and devolved administration take steps to ensure that the same approach to record retention is communicated throughout all relevant bodies, including arm's-length bodies and any other bodies exercising public functions, namely that they ensure that a full and clear record of their part in event exists, is accessible, and that they apply a precautionary principle by retaining all material that could be relevant, including emails, text or WhatsApp messages and other communications." The response you received from the Director General in February 2022 indicated that he'd written to all permanent secretaries in June 2021 about preservation of material, and that they were written to again, including the devolved administrations in February 2022, with assurances being given to you that, quote, "well-established record management processes are in place across government." The public were told in an inquiry update note for Module 2B that in October 2022 that a corporate statement had been requested from the Welsh Government, and we note today that your CTI, Mr Poole, KC, has confirmed that it was in this request that went to the Welsh Government that the request was made for informal messaging. So that's October 2022. So in short, the Welsh Government have been on notice for over 2 years, and probably longer, that they needed to retain, seize and disclose all informal messaging to the inquiry. The Welsh Government have been in receipt of a formal request for disclosure for this material for 14 months. It therefore is extremely surprising and disappointing that the inquiry has only very recently, a matter of weeks ago, received this disclosure. I mean, there is an obvious point to make here, and I appreciate it's been made a number of times on behalf of my client, but it's an important one. But it was Mr Drakeford himself, when refusing to hold a Welsh public inquiry, who insisted that the Welsh Government be scrutinised alongside the UK Government. Now, the UK Government has disclosed significant volumes of WhatsApp communications, and so the COVID-19 Bereaved Family Justice for Cymru query, if the Welsh Government want parity of scrutiny, why have they not made similar disclosure in a timely manner? To be clear, as at today's date, core participants in Module 2B have not received a single WhatsApp from the Welsh Government. I now turn to the deletion or the loss of relevant material by members of the Welsh Government in relation to informal messaging. Now, the First Minister for Wales, Mark Drakeford, said at First Minister's questions on the 7th of November 2023 on this issue that, quote, "As soon as we knew that inquiry wanted something, there's no deletion beyond that point. However, during the COVID period itself, many colleagues working for the Welsh Government will have had devices with deletion instructions already on them, and those things may have remained on their phones, because at that point, nobody, I think, absolutely nobody was focused on whether those messages might be required at some future distant point. The COVID-19 Bereaved Families for Justice Cymru are appalled that the Welsh Government has indefensibly allowed a situation in which relevant communications were either lost or deleted. They question whether it can be the case that nobody focused on the preservation of messages during the pandemic. Well, before the pandemic, it would have been obvious, indeed a requirement, that informal messaging touching upon matters of government ought to be preserved, and there had to be a policy on the retention of government records in the Welsh Government. The Freedom of Information Act 2000 Code of Practice makes it clear that public bodies should make destruction decisions in accordance with an up-to-date policy using a method or process that is applied consistently and that has been approved by the authority. Public bodies must retain information if they are to need it, where there may be a public inquiry, and policies must be flexible enough to foresee this. The COVID-19 Bereaved Families for Justice hope and anticipate that the inquiry will be scrutinising how, why and when messages came to be deleted or lost by the Welsh Government and its advisers, and the policies under which individuals claim they were operating, including the justification for the deletion, as we know is the case with the Scottish Government. We asked the inquiry to obtain and disclose all correspondence within the Welsh Government, including from Mr Drakeford, touching upon the non-destruction of material on phones. And we also asked the inquiry to ascertain whether instructions were in fact given within the Welsh Government at any stage prior to or during the pandemic on the preservation of documents, and whether there was any official or unofficial policy in the Welsh Government of deleting WhatsApps or other messages at any stage, including the use of the auto-delete function. We note the evidence of Claire Jenkins, a Welsh Government Special Advisor during the pandemic, who makes what may be considered to be a surprising comment at paragraph 22 of her witness statement, namely that she sent texts and WhatsApp communications for government business on her private phone, but that, quote, these messages were regularly deleted at this time, but in any event, she thinks that they wouldn't assist the inquiry. We also note from the very recently disclosed statement of the Senior Special Advisor Jane Runnacles at paragraph 79 to 80 that iMessage was set to delete every 30 days and that 7-day disappearing messages was used for WhatsApp messages for the majority of the groups from when that function became available. In this statement, Ms Runnacles tells us that she's in possession of WhatsApp messages, but that these will be made available to the inquiry. We query why were these messages simply not appended to the statement when it was disclosed. If the Welsh Government have actively as a cohort consciously switched to using the disappearing messages function when it became available, which we know is November 2020, this would suggest that certainly at this stage the Welsh Government knowingly adopted a policy or a system designed to delete government communications when it would have been obvious to them that such material ought to be preserved. Milady, you no doubt will be an expert on the working of the platforms of WhatsApp and the like, but just to be clear, that 7-day disappearing function didn't become available, as I said, until November 2020, and even then, this function on WhatsApp would not delete all chat messages for every participant in the group, but only the individual using that function. And in the absence of deleting messages function at the time of the pandemic, there was only a 1-hour window in which messages could be deleted. And again, such deletion would not remove the message from all participants unless everyone in the chat pressed delete for everyone, for every message in the chat. The COVID-19 Bereaved Families for Justice would then just like to ask for a further update from the inquiry setting out the Welsh Government explanation as to what happened to this material. Can we also ask for an update in relation to the status of material such as informal messaging from Public Health Wales as well? I now turn to a different aspect of apparent poor practice in relation to data preservation in Wales, and that's the retention of emails that we've just heard about from Mr Poole KC. Now, we note the reassurance that has been given by him today, but the group remain particularly concerned that deletions might still impact on the ability of the inquiry and CPs to put relevant matters to witnesses. And so we do ask for a bit more information on this topic so that the bereaved families can be satisfied that this issue is no longer of relevance to the inquiry and will no longer impact on the inquiry. So I now turn to some other matters. As my lady knows, one of the issues of concern to the COVID-19 Bereaved Families for Justice Cymru is that Module 2B and later modules scrutinise the impact of decision-making on the older population of Wales by reference to Welsh data and seek to understand the extent to which Welsh policy and legislation in place at the time of the pandemic in Wales in fact made any meaningful difference to decision-making in relation to disadvantaged and vulnerable groups, including the older population of Wales. To that end, the group support and endorse the submissions on this topic that have been made by other core participants for this preliminary hearing. In particular, they draw your attention to and endorse the written submissions made on behalf of the disability people's organisations in Wales at paragraph 1.6, namely that the inquiry is asked to focus on the gap between the rhetoric of national policies and what happened on the ground in Wales. The experience of the membership of the group is that there was a chasm between what government policy aspired to achieve and the reality, particularly for vulnerable and disabled groups. Turn to the use of experts. The group welcomes the instruction of Professor Daniel Wincott by the inquiry and notes that a first draft of his report has very recently been received and they will respond in the usual way. They also note the inquiry's reliance on certain Module 2 expert reports in respect of Wales for Module 2B. As you know, the group's already indicated their concerns that a number of these reports do not adequately cover Wales, either because there's just simply a lack of data known to those experts in respect of Wales, or a lack of Welsh-specific expertise. The gaps from Module 2 have been highlighted in our written submissions, I think, many times previously, and where possible, we ask the inquiry to seek to fill these gaps, although we note the update today in relation to the data issue. For example, as noted by John's Campaign and Care Rights UK, the report by Professors Shakespeare and Watson on structural inequalities relating to disability does not consider the intersection between disability and age, and we just draw your attention to that specific point. In relation to the venue for Module 2B, as you will know, the group have already indicated their concern with the location of the hearing venue, which is the McCure in Cardiff North. They consider it to be unsuitable because it's not centrally located and not easily accessible on public transport links. There is one bus, but it doesn't stop directly outside the venue. I mean, it's understood and accepted that the inquiry is clearly now committed to this venue, but we simply ask that the inquiry thinks about solutions to facilitate access, and it may be that that is a shuttle service located close to Cardiff Station. The group, as you'll understand, are keen to ensure that as many of its members as possible can attend the final hearing in this module, particularly as it's the only one relating to Wales. And they stand ready to give any assistance that they can to facilitate access to the hearings. Finally, then, can I take this opportunity to once again remind the Welsh Government, as we did in our opening statement for Module 1, that the COVID-19 Bereaved Families for Justice Cymru are a group of bereaved families. They have lost loved ones to COVID-19, often in terrible circumstances. Many of the group are traumatised by their experiences. However, despite this, the group are working tirelessly to assist the inquiry to bring scrutiny to the decisions of the Welsh Government on behalf of all those bereaved in Wales. My lady, this is not an easy task for bereaved individuals who are simply members of the public. Delaying disclosure right up until the last minute fundamentally undermines and frustrates their ability to scrutinise all the disclosure and in turn effectively participate in this inquiry. But the COVID-19 Bereaved Families for Justice Cymru are of course grateful for the opportunity to provide these submissions and remain committed to assisting you and the inquiry team in their work. Thank you very much.
Thank you very much, Ms. Evan, and may I repeat my thanks to you, those you represent, for the help that you've given to the inquiry so far. I very much take into account the issues that you've raised, including the one about venue, but I think you know the inquiry ended up with not many options, if not only one option, but we'll do everything we can to make sure that those you represent can participate fully in the hearings. Right, Mr. Straw.
Good morning, my lady. As you know, I represent John's Campaign and Care Rights UK. We've set out quite a lot of detail in our written submissions, and this morning I'd just like to emphasise a few key points on 3 topics. Firstly, the list of issues, secondly, Rule 9 requests, and thirdly, a few procedural points. So, list of issues. We welcome the changes that have been made to the inquiry's list of issues in the most recent version, and also the indication from Mr. Poole that the list will be kept under review. In our written submissions and this morning, I'd like to identify a few more specific sub-issues which aren't explicit on that list, for the purpose of encouraging the inquiry team to bear these in mind and consider them when it's continuing to prepare for the hearing. So when making decisions about disclosure, further Rule 9s, if there are to be any, which witnesses to be called and so on. And I'd like to focus on 8 sub-issues for this morning. The first of them is the indirect harm of NPIs, non-pharmaceutical interventions. And by indirect harm, I mean the adverse impact, other than COVID itself, of those NPIs. Now, this is a very important issue for our client group, which is broadly those in the care sector, because the adverse impact on our client group of NPIs was at least as bad as the impact of COVID itself. And that's in terms of both death, illness and serious other injury. And there are a variety of emerging themes from the disclosure which we would invite the inquiry team to bear in mind related to this. For example, failure to evaluate or take into account the adverse impact by core decision makers, failure to obtain sufficient input from appropriate experts by core decision makers, including expertise about vulnerable groups, for example, those in the care sector. Similarly, failure to obtain sufficient data and Welsh-specific data regarding the adverse impact on vulnerable groups. The second issue is failure by core decision makers to understand and properly consider the needs and rights of older people. And the third issue is similar. It's failure to understand the needs and rights of disabled people. Now, there's a particular concern for our group, which is the disabled people with mental or learning disabilities or cognitive impairment. And there's a real vacuum in the disclosure that we've seen so far of any recognition or consideration being given to those who fall into that category. There's a particularly important disability, which is dementia. I gave reasons why that's a particularly important disability in this context in the Module 3 hearing, and I won't repeat those, other than to say that dementia is the leading cause of death in the UK, and therefore we submit something that should be an important matter to be borne in mind. Disability Wales have submitted 2 points that we would respectfully endorse. Firstly, in paragraph 1.3 of their written submissions, they submit that disabled people were no more than an afterthought in core decision making, and they were given insufficient weight by central government and central administrators, and we endorse that. They also invite the inquiry to obtain an expert report from Professor Debbie Foster, who was the coordinator of the Locked Out report on this particular topic. And again, we support that. It does appear from Mr. Poole Casey's submissions that will be obtained, and if so, we're content with that. The fourth sub-issue is the care sector, so the consideration given to the care sector within core decision-making. And we're content to hear from Mr. Poole that this module will look at broad reasons why care-related decisions were taken by core decision-makers. It's important that that issue is considered by the inquiry, as it was important that the care sector was taken into account by core decision makers. These decisions in central government led to many deaths. They led to serious harm, both COVID and non-COVID, for those in the care sector. And so it should have been an issue that was front and centre of decisions being taken centrally. There are particular issues which affect this module concerning the care sector that we would invite the inquiry to bear in mind. So firstly, little engagement with those in the care sector, little engagement with stakeholders. Recommendations from the care sector weren't acted upon. There was little regard by those in central positions on the impact of core decisions on the care sector. And finally, again, a vacuum really in the disclosure that we've received so far of any consideration by core decision makers of care outside hospital or care home. And this is an often forgotten part of the health and care sector. It's a very large proportion of those being cared for are actually those who are outside hospital or care homes. The fifth issue, the fifth sub-issue, is guidance or policy. In a number of cases, guidance or policy was produced by different parts of government, different departments, about the same topic. So there may have been guidance or policy for one particular sector produced by Public Health Wales and different sections of the government, which conflicted. So it told people to do different things. And we would invite the inquiry to look into whether there was a process in place to try and avoid that sort of conflict, a process for coordinating guidance and policy. Similarly, we would endorse what Ms Heaven submitted earlier today, that there was a gap between government policy announcements or government rhetoric and what happened on the ground in Wales, and we invite the inquiry to look into that. The sixth issue is the disclosure indicates that that duties arising from equality and human rights legislation were overlooked or breached in core decision making. So, for example, due regard duties or reasonable adjustment duties appear often to have been ignored. Now, of course, government has had a great deal on its plate during the pandemic, but if anything, those duties were more important during a pandemic than otherwise. Similarly, regulatory bodies such as the Equality and Human Rights Commission were often overlooked. The seventh issue, the disclosure so far indicates that there was, at a relatively early stage, evidence of high levels of hospital-acquired infections, and that those weren't recognised or properly acted upon in core decision-making. And the obvious example is discharge into care homes, but there are other core decisions as well where that wasn't properly recognised. The final eighth issue is lack of record keeping. Ms Heaven has already made detailed submissions on that, which I need not repeat, but we endorse those submissions. My lady, the second topic I'd like to turn to now is experts and Rule 9 requests. We do invite the inquiry to call expert evidence regarding the care sector for the purpose of this module. Now, that need not be a specific separate report, but assuming the inquiry will be obtaining a report for Module 6, the care sector module, then if that can be prepared in time, we would invite the inquiry to include in that a section on core decision making. And that's really to reflect the importance of what happened in the care sector to core decisions, so the very high number of deaths that were caused, the very high number of serious injuries, serious illness that was caused by core decisions in the care sector. And we would submit, on the basis of the evidence that's been disclosed so far, that those in core decision positions did not have sufficient understanding of the care sector. For example, a basic point, the difficulty in isolating those entirely dependent on others for care and survival. And it would be helpful, we submit, for an expert to include a section in the report on the peculiar characteristics of the care sector and those in care and how that should have impacted on core decisions. We've put forward in correspondence an individual called Mark Llewellyn, who is the Director and Professor of Health and Care Policy at the Welsh Institute for Health and Social Care. We invite the inquiry to consider him. On outstanding Rule 9 requests, we invite the inquiry to consider, if it's not already done so, obtaining a statement from Learning Disability Wales. Learning Disability Wales were part of a report that was produced in February 2022 in combination with Warwick University about the impact in Wales specifically of the pandemic on those with learning disabilities, for example, autism. And we invite the inquiry to consider obtaining a report from Learning Disability Wales. It's likely to be of significance to issue 3B, that's the impact on vulnerable groups of core decisions. It's unclear from what we've seen so far whether full evidence has been sought by the inquiry on the adverse impact of NPIs on vulnerable groups in Wales. For example, the impact of those on carers or visitors, the impact of the restrictions on carers and visitors on others, expertise and data. So has sufficient witness evidence been obtained as to what expertise and data was available of the impact of NPIs on vulnerable groups? And if that hasn't already been done, then we invite the inquiry to do that. One body that may be able to help is Social Care Wales, who would be in a good position to give evidence about that. The last point about Rule 9s is the written submissions of COVID-19 bereaved families for justice in paragraph 3 invite the inquiry to obtain evidence in relation to older people in Wales, particularly those receiving care outside a state setting, and we would endorse that request. Lady, the third topic I'd like to turn to now is a few procedural matters, preparation for the final hearing. CTI has mentioned the provisional list of witnesses. We would be grateful if we could have an opportunity to make submissions about the provisional list of witnesses when it's produced. The timing is, of course, difficult. We're well aware of the difficulties and the pressures that the inquiry is under. It's important that the time in which we make submissions is after sufficient information has been disclosed so that they can be effective submissions, but giving us enough time prior to the inquiry so that they can be made at a time when witnesses can actually be called. A similar issue, Mr. Poole has mentioned that key documents, for example, about uncontroversial background, will be produced by the inquiry, and draft evidence proposals for witnesses will be produced. Again, we'd be grateful for an opportunity to comment on all of those, and again, in sufficient time for us to be able to do so effectively. I'm sure your ladyship is well aware of this. Our client groups have full-time jobs. Some of them have protected characteristics themselves, so the more time that can be given to us, the better. Mr. Poole has indicated that instructions given to experts won't be disclosed. We would ask you to consider that issue, not necessarily to disclose those in advance, but to disclose those at the same time as disclosing the reports themselves. And the basic reason for that is that in some instances it's been difficult to understand the contents of the reports without the letters of instruction. So without that context of the question that were asked, it's difficult to understand the answers that were given. And we, in our submissions at paragraph 31, outline a few particular examples of that happening. The final point I'd like to raise is context for certain disclosure. We deal with this in our written submissions at paragraph 32 onwards. It's sometimes been difficult to understand the significance of some of the disclosure that we've received, and would be grateful for the inquiry to consider giving more context about the particular points we've raised. One example is WhatsApp messages. So in some instances, it's unclear who was in the WhatsApp group, what its function was, and that makes it difficult or impossible to understand the significance and the impact of those messages. My lady, that's all I hope to cover for today, unless there's anything else you'd like me to address.
No, thank you very much indeed, Mr. Straw. You make some obviously very important points, and I'll bear them all very much in mind. Thank you. I think we'll take a break now. Where is Mr. Howes? Oh, he's there. Right. I was assured that I'll have a clear line of sight, Mr. Howes. Maybe if I take the break and we can make sure that I do have a clear line of sight. I'll return at 25 past. Thank you. Now I can see you, Mr Howells.
My Lady, Borodar. The Welsh Government is grateful to Counsel to the Inquiry, Mr Poole, King's Counsel, for acknowledging the significant efforts that the Welsh Government has made to comply with all requests made of it by the inquiry. In addition to Module 2B, the Welsh Government is a core participant in 5 other modules. Few other governmental core participants have a similarly intense involvement in the inquiry. That brings a very heavy workload, but the First Minister and the whole Welsh Government consider it to be vital that its decision-making in the pandemic, which affected everyone in Wales and every aspect of life in Wales, is examined, tested, and judicially considered. Given the scale of the response to the pandemic, fair and impartial scrutiny of the Welsh Government's actions is necessary. It is for that reason that the First Minister, uniquely, volunteered to give evidence and to be examined in Module 2, so that you heard evidence from at least one other head of government about the operation and effectiveness of intergovernmental decision-making during the pandemic. This is, we hope, a telling and practical example of the Welsh Government's willingness to submit itself to scrutiny. It may help those following today's hearing to know the extent of the Welsh Government's contribution to Module 2B's work so far. It has provided over 75 statements in either final or draft form, with a small balance to be provided imminently and certainly well before the start of the hearings next February. It has disclosed more than 24,000 documents to date, a significant volume of material which includes documents that are relevant to the matters that your Ladyship will consider in Module 2B. The Welsh Government will continue to meet its duty of disclosure and provide any further material that is sought, including all specific disclosure. The materials which have already been provided to the inquiry and future disclosure will include, but is not confined to, advice to ministers throughout the pandemic from January 2020 onwards, and the supporting material which was provided with that advice, the scientific and other evidence which ministers considered when making decisions, relevant minutes, relevant email and other correspondence, and other material which explains and illustrates decision-making in Wales during the material time. When the Welsh Government's disclosure is provided to core participants, it is, of course, subject to the inquiry's procedures. Finally, in February and March next year, you will hear evidence from the Welsh Government, including officials and ministers. Those witnesses will be examined by Counsel to the inquiry on the basis of the materials that ministers relied upon in making decisions and officials in giving advice. The inquiry will receive the fullest cooperation from all those witnesses. WhatsApp and other similar forms of communication have featured prominently in recent hearings and in media coverage. In relation to Wales at least, you may conclude in your report that the high-profile coverage of WhatsApp messages was disproportionate to its true forensic value in examining or illustrating the Welsh Government's decision-making. That, however, will be a matter for your Ladyship to decide in light of the whole body of evidence that will be adduced in Module 2B, of which WhatsApp communications are a minor and peripheral part. At the end of September this year, the inquiry and the Welsh Government agreed the approach to be adopted in relation to the appropriate management of WhatsApp and similar communications. Between the 3rd of October this year and today, the Welsh Government has disclosed batches of WhatsApp, text message transcripts and screenshots to the inquiry and will continue to do so. It should be borne in mind that the process of searching for these materials is time-consuming, intensely demanding of limited resources, and, on occasion, technically problematic. The Welsh Government has kept the inquiry regularly informed about progress of the complex process of gathering WhatsApp and other communications from many individuals, some of whom have left office or no longer work for the Welsh Government. It will, of course, continue to do so. Following discussions between the Welsh Government and the inquiry about the substance and focus of the inquiry's requests, on the 25th of October this year, the inquiry asked some specific questions about WhatsApp communications, which usefully distilled matters. The Welsh Government has provided a comprehensive response to that request by the deadline of the 8th of December. My Lady, finally, may I thank again Counsel to the Inquiry, Mr. Poole, King's Counsel, and his team for their positive, practical and constructive approach throughout their work in Module 2B. Although we may not always agree, the Module 2B team has been consistently courteous, appropriately demanding and always rigorous in carrying out their investigation, a balance which is not always easy to find or to maintain and to do so fairly. My Lady, unless there are any other matters, those are my submissions.
Thank you very much indeed, Mr Howells. Very grateful. Mr Poole, anything to conclude?
My Lady, may I briefly attempt just to deal with 4 issues which in our submission require to be responded to and can usefully be dealt with straight away. The first, delayed disclosure. As I said earlier this morning, we have received everything that we anticipate receiving, and we will provide material to core participants as soon as possible, which inevitably is probably going to tip into the new year. As regards the 3 statements specifically mentioned by Ms Heaven on behalf of COVID-19 Bereaved Families for Justice Cymru, namely the statements from the First Minister, Mr Drakeford, Mr Gethin and Eleanor Morgan, they will be disclosed before Christmas, failing which very early in the new year, and they are all at the final review stage. The second issue, informal communications. Again, in response to submissions made on behalf of COVID-19 Bereaved Families for Justice Cymru, I can confirm that the Rule 9 questions that were in the Rule 9 sent out by the Module 2B team included questions on informal WhatsApps and other messaging platforms, texts and iMessages. As regards the issue of retention and deletion, we are reviewing, as I said earlier, the recent response received from the Welsh Government regarding the use of WhatsApps and other informal methods of communication. And the CPs can rest assured that we will pursue the issue until we are satisfied that the issue is fully investigated, and we will provide an update on this issue to core participants in due course. And of course...
Sorry to interrupt you. I think Ms Heaven also mentioned Public Health Wales in relation to deleted messages.
My Lady, yes, and I include Public Health Wales within that, and we'll provide an update to core participants in respect of all of those in due course. We'll also, of course, provide the materials when we can. The third issue I wanted to mention was list of issues and Rule 9 recipients. In response to submissions made by Mr Straw Casey on behalf of John's Campaign and Care Rights UK, the inquiry is very alive to the issues that Mr Straw has identified. We will reflect on the specific issues when putting together the evidence proposals before circulating to core participants for their input. We will also consider the individuals and bodies that he's identified and reflect on whether further Rule 9s should be issued. And I can confirm that the inquiry has already sent a Rule 9 request to Professor Debbie Foster. And then finally, on the provisional list of witnesses and evidence proposals, I can confirm that the core participants will be given the opportunity to provide their comments on the provisional list of witnesses in advance of that list being finalised. We hope to be able to share that draft list with core participants this week, and we welcome their observations in due course. And we will also write very early in the new year to core participants explaining the timetable for evidence proposals and core participant contributions. My Lady, they're all my submissions.
Very grateful, Mr Poole, and indeed I'm extremely grateful to everyone who's made submissions today, and indeed anybody who's made submissions in writing in the past. It all bodes extremely well for an effective investigation in February and March. The focus and the constructive nature of the submissions are very welcome. So thank you all very much indeed. And I'm afraid my Welsh isn't good enough to say look forward to seeing you in February, March, but maybe you can give me some lessons, Miss Heaven or Mr Howells. Actually, no, I think I may have somebody in the inquiry who can give me lessons. Thank you all, and I will rise now until, is it 1:45? When I'm going to start to see preliminary hearing. Anyway, for those who need to know, we'll make sure a message is there. Thank you.
All rise.
Good afternoon. This is the third preliminary hearing into Module 2C. Ms Claire Dobbin, Counsel to the inquiry for this module, is going to set out the issues that are going to be put before me this afternoon.
Thank you, my lady. I appear today with Nick Scott, and on behalf of the Council team, I just want to welcome those representing core participants who are joining this hearing from Northern Ireland, and of course those who are present before you as well. This is a hybrid hearing. It's being broadcast so that anyone who wants to is able to join it. Of course, that means that it's subject to a 3-minute delay. That means if anything is said that ought not to be, the feed can be broken. We don't expect anything like that to happen today, but I just thought I'd mention it because these short interruptions can sometimes happen. So before you in the inquiry room are Mr. Peter Wilcock, King's Counsel, who represents the Northern Ireland Bereaved Families for Justice, Miss Nessa Fee, who appears on behalf of the Executive Office of Northern Ireland, and Miss Charlotte Godber, who represents the National Police Chiefs Council. There are a number of core participants who also appear before you today by way of remote attendance. A number of these will be familiar to you. Disability Action Northern Ireland are represented by Bat Murphy Solicitors. Baroness Arlene Foster and Mr. Paul Given are represented by Miss Julie Ellison. Miss Michelle O'Neill is represented by Mr. Bassett and Miss O'Flaherty today, and O'Murray Solicitors. The Commissioner for Older People for Northern Ireland is represented by Miss Anya Dika Daines, King's Counsel. The Northern Ireland Department of Health is also represented, and by Fiona Fee, and the Departmental Solicitor's Office as well. And the Northern Ireland Department of Finance is also represented by Nicholas Hanna and the Departmental Solicitor's Office. My lady, as you know, the Trade Union Congress and the Northern Ireland Committee and the Irish Congress of Trade Unions are also core participants, but they are not in attendance at today's hearing. My lady, by way of introduction, may I say how grateful I am to all of my learned friends for their help and engagement, including with me in the lead up to this hearing. Of course, it corresponds with the close of the evidence in Module 2, and the Module 2C team thought that it was important at this juncture and ahead of this hearing to make contact with the other legal teams representing core participants, just asking them to consider or reflect upon any linkage that there was between the issues that had arisen in Module 2C, Module 2 and Module 2C, that they might want to raise with us, or anything new that had arisen. Plainly, what happened in the devolved administrations is the other side of the coin to the events being investigated in Module 2. And it's anticipated that much evidence which you heard in Module 2 will be just as important to those who were involved in making analogue decisions in Northern Ireland, and those whose lives were so profoundly affected both by COVID-19 and government decision-making in Northern Ireland. And if any of my learned friends to whom I've not spoken would wish to make submissions today about that, then of course they would be welcome. But I wanted to emphasise that they will also have that opportunity to discuss those matters with us when the inquiry team visits Northern Ireland in January to have those meetings. And if I may, I'll come back to that very shortly. My lady, you have in your bundle, and the legal team has, in preparation for this hearing, circulated to core participants an updated list of issues. And I want to thank my learned friends again for contributing to that with care. We're all aware that it is an ambitious list, but it ought to assist important witnesses who are in the process of preparing their witness statements. And it ought also to provide the focus for the hearings which will take place in due course. And I'll come back to the detail about those hearings as well. But on the subject of witness statements, I wanted to make clear, if I may, on behalf of the legal team, and wanted to acknowledge at the outset of this hearing that the Module 2C team has been demanding in terms of what it has asked of government departments and individual witnesses in Northern Ireland. The inquiry team is aware that the absence of power sharing arrangements has added to pressures on departments and civil servants, specifically in responding to this inquiry. Additionally, parts of the Northern Ireland Government and individual witnesses have had to respond to Modules 1, 2 and 3, whilst simultaneously responding and providing disclosure to Module 2C. We're also aware that they don't have comparable resources to those of the UK Government as well. It's right that we acknowledge that the Executive Office alone has provided already in excess of 24,000 documents to Module 2C. And we also know that many of those individuals of whom we have sent detailed Rule 9 requests are, for the most part, public servants and have demanding jobs. And we're conscious and mark that a heavy burden has fallen on the Northern Ireland Chief Medical Officer in this regard. But my learned friends will well understand that this is an inquiry where that underlying detail matters. We will not, and we would never have time in a public hearing to call witnesses to investigate each and every aspect of the decision-making or to take them through every relevant document. That's not realistic. The underlying material is therefore necessary in order to inform the detailed questioning of witnesses for report writing and, of course, most important, the making of recommendations as well. The Module 2C legal team has sought to be as accommodating as it possibly can be, given the pressures that Northern Ireland Government departments are subject to. We have provided extensions to Rule 9 requests. We've tried to stagger Rule 9 requests as well. But as the hearing gets closer, inevitably the ability to afford latitude decreases. We wanted to mention that today on behalf of the inquiry because it's particularly important that former ministers bear this in mind. The inquiry sent detailed Rule 9 letters to those former ministers, and in respect of a number of them, they were about 50 pages long or longer, contingent on the level or the range of responsibilities that that individual had. Ministers were referred to a number of underlying documents in order that they could provide a response to the inquiry that was first of all structured, but which also addressed the detailed list of issues which has been circulated. I do want to make it clear that many ministers are in the process of providing their first drafts to the inquiry, and we haven't had sight of them. So the observations that I make do not apply to all ministers. I wanted to make clear that as part of the preparation for the hearings, and of course to ensure that they're effective, we are closely monitoring the compliance of witness statements with the questions that have been asked in the Rule 9 request whenever a draft comes back. We are in the process of going back to some former ministers because the statements they've provided do not sufficiently engage with the underlying material which was put to them. Whilst no final decisions have been made about who will be called to give evidence, it is likely that each former minister will be called at the hearings. There will be no hesitation in the hearing about making clear the question which any witness was asked, but failed to properly engage with or answer in their written statement. Witnesses who fail to answer questions they have been asked to address in a witness statement will have to account for that failure on oath in the witness box, and they will ultimately have to answer those questions as well. I should also mention, of course, my lady, that you do have the power to compel the production of written evidence under Section 21 of the Inquiries Act 2005. It's hoped that this will not be necessary. Plainly, it's in no one's interest, but certainly not those of the witness, to fail to engage in the process of providing detailed evidence in writing prior to giving oral evidence. My lady, it's worth reflecting and, of course, reiterating that one of the most important reasons why this inquiry was instituted was to make recommendations and to consolidate that which has been learnt from the response to the pandemic. In its report of the 9th of March 2023, the Northern Ireland Statistics and Research Agency estimated that there were 4,075 excess deaths in Northern Ireland from the 1st of March 2020 to the 31st of March 2022. In the same period, there were 5,060 COVID-related deaths in Northern Ireland. My lady, as you know, having just heard this evidence, Professor Sir Chris Whitty, in his evidence in Module 2, said that he perceived a difference between how the UK system collectively approached geopolitical threats like terrorism as compared to how they approached natural threats or hazards. Put simply, if government knew that there was a terrorist event in the planning and that thousands of people might lose their lives, then that might or would prompt a different sort of response as compared to that of a developing pandemic. You haven't made any findings in Module 2 or about those observations, but nonetheless, Professor Sir Chris Whitty's framing of the issue might be a helpful one, and one that might resonate also in Northern Ireland. Faced with information that this was a pandemic which might kill thousands, and of course the point at which that was understood by ministers in Northern Ireland is extremely important. Did ministers grasp the urgency and respond with alacrity? Did the civil contingencies arrangement kick in and provide an effective framework within which to manage the pandemic? Fundamentally, were there limitations in the response, and what were the reasons for them? To what extent was any response in Northern Ireland conditioned by the response by the UK government, which Module 2 has thrown more light on in the course of its investigations? The position of Northern Ireland during the pandemic was, of course, completely different to that of the UK and indeed to the rest of Europe. It affords the inquiry to consider the unique challenges which present themselves in a post-conflict society and which governs on the basis of power sharing. These are important issues deserving of the most sober and serious consideration. And returning, if I may, to former ministers, their written and oral evidence will obviously be vital for considering all of these important issues and what could be done better in the event of a future pandemic, and of course one which might be more transmissible or have a higher fatality rate, the prospect of which is not fanciful. The people of Northern Ireland are as entitled to full consideration of this as in any other part of the UK, and we on their behalf will strive to get the answers to those issues which have been identified. So may I, on behalf of the inquiry, say to former ministers and indeed all witnesses to help the inquiry by being candid, by putting aside political differences or sensitivities, and helping the inquiry to understand the realities of responding to the pandemic in Northern Ireland. And can I say on behalf of the legal team that our door is always open in terms of providing assistance or guidance or anything that we can do to help achieve this. And if I may then, my lady, coming back to the meetings that I mentioned in January, the legal team will be there in order to meet core participants and to discuss the hearings which will commence on the 30th of April 2024. As ever, it's an opportunity for us to listen and to make sure that we have understood any outstanding issues or points that need to be resolved well in advance of the hearing. My lady, that's all by way of introduction. Can I turn then to update? Module 2C's at a critical juncture. The hearings will start in less than 5 months' time. We, of course, have the luxury of being the last of the hearings in the devolved administrations, And that has afforded us the opportunity not just to put specific evidence to witnesses before sending them out Rule 9 requests, but indeed being able to put evidence that was heard in Module 2 to some witnesses as well. But as I've said, time is increasingly short. We alerted core participants in the pre-hearing note to the fact that the Department of Health in Northern Ireland had been particularly slow in responding to the Rule 9 request made of it for a witness statement and the requests made of it for disclosure. I can update you, though, that since that note was circulated, the Department of Health has provided its draft witness statement. It's in 3 parts and is approximately 527 pages long. The statement exhibits 1,069 documents. I can also say that the department is in the process of providing its general disclosure, and again that the Module 2C legal team is working with it to ensure that its general disclosure exercise is focused upon the most important categories of material having regard to the Module 2C list of issues. And as ever, we try to get the balance right between that disclosure which is unfocused and not helpful, and that which will be most relevant to the list of issues. My lady, then in terms of the Rule 9 requests, the statements and the exhibits that we have sought and received, I can tell you that we have sought witness statements from or on behalf of, amongst others, first of all, the Executive Office itself, every government department in Northern Ireland, the Northern Ireland Office, the Public Health Agency, the Health and Safety Executive in Northern Ireland, the Police Service of Northern Ireland, NISRA, which is the statistics agency that I referred to earlier, and the Regulation and Quality Improvement Agency, and that's the body in Northern Ireland which both registers and inspects a range of health and social care services. We've sought statements from former and serving senior civil servants who are central to the response to the pandemic. So amongst a number, these include Sir David Sterling and Mr. Richard Pengelly. We've sought a statement from Miss Sue Gray, who was the former permanent secretary to the Department of Finance in Northern Ireland, who was on secondment from the Cabinet Office and who was the second permanent secretary to the Cabinet Office. We hope that she might be able to assist as to some of the significant differences in terms of how the civil service operates at central government as compared to Northern Ireland government, and also to see if she may provide helpful evidence on the differences in that role in the context of power sharing as well. We've sought statements from the Chief Medical Officer and the Chief Scientific Advisor. We've made a further detailed request of the CMO. We've sought statements from some of those who were involved in actual modelling in Northern Ireland. We've sought statements from specific special advisors, from the former Secretary of State for Northern Ireland, Sir Brandon Lewis, and most significantly of all, statements from each minister who was in post from the return of power sharing in January 2020 through to 2022. And again, my lady, as you would expect, we've also sought statements from those organisations who represent the different interests of groups within Northern Irish society as well. And I know a number of these will be familiar to you, but they include the Equality Commission, Mr. Eddie Lynch, who's the Commissioner for Older People, who you know, and Disability Action as well. So that's to give you an idea and to give core participants an idea of the extent of the evidence which has been sought. In terms of onward disclosure to our core participants, to date, Module 2C has received in excess of 35,000 documents. These include notes and minutes of executive committee meetings, the briefing papers that were circulated for ministers for consideration at the executive committee meetings, internal departmental briefing papers, notes and minutes of meetings, the advice provided by the CMO, and documents setting out the modelling of the pandemic in Northern Ireland as well. Now, of course, not all of those 35,000 documents will necessarily be relevant and disclosed on. The inquiry thus far has disclosed over 12,000 documents, and of course that process is ongoing and continues. So Module 2C has disclosed a very considerable volume of material. And my lady, if I may, I wanted to thank the team of paralegals who have achieved this. They work really hard at a difficult task and one which goes unseen, but they are the engine room of providing disclosure to core participants. And I'm very conscious that the Module 2C team is about to enter a period of really hard work in terms of getting in a number of witness statements and exhibits. And it's right to say and mark that the paralegal team will play a really important part of our work in enabling us to provide the onward disclosure to core participants. The other part of that work is, of course, the cross-disclosure from Module 2 as well. There is an obvious body of material from Module 2 that will be relevant to Module 2C. So by way of very simple example, there will be all of the material like the SAGE minutes or advice, the NERV tag documentation, which will need to be put to certain witnesses in Module 2C as well. As part of the exercise of ascertaining what information was known in Northern Ireland at or around the same time it was known by the UK government. And I should say that relevant documents from Module 2 are also being disclosed in Module 2C on a rolling basis. And of course, my learned friends may also wish to flag to us any material in particular that they, on behalf of a core participant, consider to be relevant and important from Module 2C, if by any chance this hasn't been disclosed. My lady, the Module 2C team is also aware that some core participants were told in Module 2 that some of the questions they sought to ask would be more relevant in Module 2C. And the invitation is made to all my learned friends that it would be helpful if they gave us sight of any questions that they were told should be asked in Module 2C or would be more relevant, and in particular if they flagged up those questions which they regarded as most important and which they didn't get the opportunity to ask. And again, it's just to make sure that we have early sight of that and can think about it at this stage. My lady, may I turn then to the issue of WhatsApps and other informal forms of communication. My lady, Module 2C saw some focus on communications via WhatsApp or similar types of communications. These sorts of communications may be of a forensic value in preserving what individuals thought or knew at a given point in time. And in these submissions, I will refer to WhatsApp, if I may, as a shorthand for all similar forms of informal communications. Before I address you on that, I think it's important, though, to say that in Module 2C, we do have the handwritten notes of the Executive Committee meetings, and these do provide the inquiry with some insight into the different positions that were taken by ministers when it came to those core important decisions upon which we're focused, and of course convey those decisions which were more particularly fraught. We can see in the underlying notes criticisms that ministers appeared to make of each other or material that they had been provided with, and indeed in Northern Ireland some ministers made public differences of opinion as well. Ultimately, if I can distill it in this way, what the inquiry is concerned with are those decisions which ministers actually made, the process by which they made those decisions, the information that was available to them, and the effectiveness of the core Northern Ireland government response to COVID-19, all to the end to considering what might be done better in the future. There will be many sources of evidence upon which those matters can be assessed, and again, the Executive Committee notes will be of great use in that. But turning to WhatsApps, In June 2021, following the Prime Minister's confirmation that a statutory inquiry into the pandemic would take place, the Director General Propriety and Ethics in the Cabinet Office, Mr Darren Tierney, wrote to the permanent secretaries of each devolved administration, asking them to take steps to ensure that their departments would be ready to meet their obligations when the UK COVID inquiry began its work. And in particular, the departments were asked to ensure that no material of potential relevance to the inquiry was destroyed. On the 20th of January 2022, Ben Connor, now Secretary to the inquiry, wrote to Mr Tierney asking that this message be reiterated across the departments. Mr Connor, in particular, drew attention to the retention of material, including emails, text or WhatsApp messages and other communications. Following the inquiry's request, Mr Tierney again wrote to permanent secretaries, both of Whitehall departments and of the devolved administrations, reiterating that message and reminding them of their obligations under the Inquiries Act 2005. And my lady, I should say that the inquiry's correspondence about this is publicly available on the website as well. In September 2022, Module 2C sent a Rule 9 request to the TEO asking to be provided with information concerning the extent to which there was informal communication, including by way of WhatsApp, and similar requests were made of the Department of Health and the Public Health Agency in October 2022 and the Chief Medical Officer in November 2022 as well. So in other words, at an early stage, Module 2C sought to understand whether and to what extent these informal channels of communication were used in Northern Ireland as part of the government response to the pandemic. And this was sought so that the legal team had an informed basis then upon which to send Rule 9 requests in order to elicit messages. But ultimately, the detail that was sought wasn't provided. In late July 2023, the inquiry wrote to the TEO requesting detailed information about the use of WhatsApps in connection with the Northern Ireland Government decision-making during the pandemic. We sought policies surrounding their use and details of groups and individual use of those forms of messaging. This request was subsequently provided by TEO to all Northern Ireland Government departments for their individual response. In August 2023, the Executive Office notified the Module 2C legal team of a potential loss of data in relation to the Northern Ireland Civil Service supplied devices that were held by former executive ministers and senior civil servants. TEO informed the inquiry that the government supplied devices of the former First Minister, Baroness Arlene Foster, and the Deputy First Minister, Miss Michelle O'Neill, had been reset to factory settings. It was said that this was also the position in relation to other ministers and meant that no data was available from those devices. The Module 2C legal team immediately expressed grave concern that this should have occurred and immediately sought the detail of what had happened. TEO informed the inquiry that it would ascertain the circumstances in which the data loss arose. This became a formal investigation. A report was initially due to be provided to the inquiry in October 2023, but was ultimately provided late on Friday evening just gone, that is the 8th of December. The inquiry, in advance of this, had also issued a further Rule 9 request to the Executive Office, seeking a witness statement which provided details of the use of personal and civil service supplied mobile devices by Northern Ireland Government ministers, special advisors and senior civil servants, the policies concerning the use of such devices, the extent of the use of informal messaging systems like WhatsApp, and the applicable policies regarding their use, and particularly evidence of the circumstances and the extent of the potential data loss incident described above. That draft statement was also due on the 8th of December, but is now overdue. TEO have indicated to the inquiry that it will be provided either this week or before Christmas. But, my lady, the inquiry will be fixing a date by which that statement must be received. That Rule 9 request required disclosure of the investigation report and copies of all relevant informal communications, including messages sent by way of WhatsApp or any other informal messaging platform between ministers, advisors, party officials or senior civil servants concerning the management of the pandemic during the relevant period. And again, on the 21st of November 2023, the Module 2C legal team sent a similar Rule 9 request across all Northern Ireland departments seeking the same disclosure. And again, in respect of the same groups of people as well. My lady, because the report was only served late on Friday evening, the legal team has had limited ability to analyse its contents and to consider next step. Plainly, it requires very careful consideration, but so too does the witness statement, which we expect to receive imminently as well. In addition to all of that, and all of that work which has been done by the inquiry, in addition to the evidence that has been sought from the Executive Office, in October and November 2023, the detailed Rule 9 requests were issued, and that was as part of the general process of sending Rule 9 requests to significant witnesses, including the former ministers, which included a request to them for disclosure of WhatsApp messages from each of those witnesses. It's important to say that in all, that approach has begun to yield material. Module 2C has received WhatsApp material from Northern Ireland Government departments, including TEO. A number of individual witnesses, including former ministers, have also provided some evidence as to their use of and retention of WhatsApp messaging as well. And we are in the process of reviewing the WhatsApp material which individual ministers have been provided. So, my lady, if I may, cutting through this, that some devices have been reset does not mean that there isn't WhatsApp material. There is, but we will continue to work to secure that WhatsApp material which is still available, alongside the separate consideration, of course, as to how certain devices came to be reset in the first instance. Like much in this inquiry, it may be a question of balance and judgment. Whilst WhatsApps can yield nuggets of unvarnished thought or plain speaking and help to pin down what was known or thought at a given point, and Module 2C wishes to be able to consider the use of informal communications and what they reveal, we do need to be careful that the use of WhatsApp doesn't deflect attention or divert resources away from the long list of serious issues that need to be considered in Module 2C and the voluminous evidence which does exist about decision making. My lady, of course, the question of the wiping or the resetting of devices itself remains at large, but you will undoubtedly want to have time to properly consider the report produced by the TEO and the witness statement. You may also wish to consider the issue of the resetting devices as part of your overall consideration about the use of informal communications in Module 2C. So I suppose, in other words, you may want to hear evidence or understand more about the extent to which informal communication was used and was regulated, including about the preservation of messaging. You may wish to be able to judge overall the effect of any wiping or resetting devices in light of material which is disclosed and having heard from witnesses as to the use of WhatsApps more generally. So, in other words, you may wish to consider these issues in a broader evidential context, and that may be a matter which you wish to keep under review. I should also mention that inspection of the notebooks which TEO has been able to make available has taken place. Some 26 notebooks have been inspected thus far. I think at paragraph 17 of the Executive's Office submissions, it suggests that TEO holds notebooks used by other officials in the event that these may be requested for disclosure. If this is to suggest or gives the appearance that the inquiry has not been pursuing inspection of all notebooks, it's not correct. On the 23rd of November, after the inspection of the notebooks took place, the inquiry asked TEO to confirm that it had provided a complete list of the custodians of notebooks held by the Executive Office. They were asked whether it was contemplated that further notebooks would be made available for inspection at a later date. And the inquiry has since received from the Executive Office a definitive list of all further custodians of notebooks that are held by the TEO. And obviously, further consideration has been given to what of those notebooks should be inspected by the inquiry. And again, my lady, I should make clear that all individual witnesses have also been asked that they provide their notebooks or other form of written records. And other Northern Ireland departments have also been asked to provide a list of notebook custodians as well, again, to assist the inquiry as to what further notebooks may be inspected. My lady, may I turn then to the separate issues in terms of the list of issues and plans for the hearing in Northern Ireland beginning in April and the provisional list of witnesses. As I said at the outset, the list of issues in Module 2C is an ambitious one. Ensuring that each issue is investigated and considered will require rigour and discipline on the part of all, in particular at the oral hearings. A number of core participants commented on the list of issues, and the list of issues was amended in light of this. Where suggested changes weren't made, it was because the legal team considered that the issues fell within one of the broader issues that had already been identified. We've sought to strike a balance between a detailed list of issues and being too prescriptive. We've sought consistency where we could with Module 2 and 2A and B, but clearly there are a number of issues which find no analogue in Module 2 or the other administrations. As to the oral hearings, they will commence on the 30th of April 2024. They will last for 3 weeks. They'll take place at the Clayton Hotel, which is in central Belfast. In order to try and assist with the preparation of the hearing, and in order to help focus the hearings and the issues that are of most consequence, we will provide a number of documents as an aid. So we will provide a chronology of key decisions and events, preparation of which is well underway, key statistical information which Counsel to the inquiry will use in setting out background information like health inequalities on the eve of the pandemic and overall figures, for example, relating to deaths and as they took place at specific points in time, and the evidence proposals for witnesses as well. We will circulate in January 2024 a provisional witness list and timetable, which the legal team will also be able to discuss with core participants when we meet them next year. The Module 2C team has written to potential witnesses, and again, I emphasise potential, to put them on notice of the dates of hearings and to ask them to provide any dates to avoid. No decisions have been made as to which witnesses will ultimately be required to give evidence. As noted, it's likely that all former ministers will be called, given that they comprised the executive committee. The inquiry expects to receive, as I've said, those statements in the coming weeks. And will obviously hear representations from core participants as well as to which witnesses ought to be called. So because a witness has been asked to provide dates to avoid, it doesn't mean they will necessarily be called to give evidence. It's also possible that additional witnesses will be identified as well and required to give evidence who haven't yet been notified. My Lady, on behalf of the Module 2C team, we also very much hope that those whose interests are represented by organisations like Bereaved Families and Disability Action Northern Ireland and the Commissioner for Older People will come to the hearings. They will be most welcome. My Lady, in Module 2, a number of experts were also instructed, and their evidence will also be relevant to Module 2C. If I may just very briefly touch upon those. As you're aware, Professor Thomas Hale from the Blavatnik School of Government gave evidence in Module 2 as to international data relating to the pandemic, and he undertook a comparative analysis of decision-making in the UK and each devolved administration in relation to COVID-19. And he gave evidence, and his report was adduced on the 11th of October in Module 2. And also, Professor Ailsa Henderson from the University of Edinburgh gave evidence on devolution within the UK as well, and her report was also adduced in October. Other expert evidence, which is of indirect relevance to Module 2C, but nonetheless important background, was given by Alex Thomas and Gavin Freegard as well. And that was evidence on the decision-making structures of the UK government in emergency situations, and in particular how the Cabinet Office, Cabinet Committees and the Office of the Prime Minister function. Gavin Freegard provided evidence about access to and use of data by the UK government during the pandemic. And my lady, I should point out here that witnesses in Northern Ireland, like the Chief Scientific Advisor and the Chief Medical Officer, have been asked to provide evidence about any limitations on the availability or quality of data in Northern Ireland. My lady, in your ruling of the 9th of March 2023, you directed that the inquiry should obtain evidence from an expert or experts on the nature and degree of pre-pandemic structural racism. Your ruling provided, at paragraphs 36 and 37, that expert evidence should be obtained regarding pre-existing structural discrimination on other grounds. And as you're aware, this led to the inquiry obtaining expert evidence in relation to a number of different groups across society. And that evidence is also relevant to Northern Ireland as well. And again, if I may summarise, Professor James Nasru and Professor Lelia Becares provided evidence on pre-pandemic inequalities on grounds of race. That was adduced on the 5th of October 2023 in Module 2. Professor Thomas Shakespeare and Professor Nicholas Watson provided evidence on pre-pandemic inequalities related to disability, which of course is an important issue in Module 2C. Professor Leila Becares also provided evidence on inequalities experienced by the LGBTQ+ community. And again, that was adduced in the course of Module 2 as well. Dr. Claire Wenham, who's a Professor of Global Health Policy at the LSE, provided expert evidence on pre-pandemic gender equalities. And again, that was adduced in the course of Module 2. My lady, I note in relation to gender equality in Northern Ireland, there is a specific issue about the availability of abortion services during the pandemic, and again, that is something about which we've sought evidence. Professor David Taylor Robinson provided evidence on pre-pandemic childhood inequalities. Separate to the Commission of Evidence on Structural Inequalities, the inquiry also obtained expert evidence from Professor Chris Breitling and Dr. Rachel Evidence on long COVID as well. And again, that was adduced in the course of the Module 2 public hearing. So, my lady, if I can summarise it in this way, you considered a very broad span of expert evidence in Module 2, and in particular evidence that illuminated the extent to which certain groups within society faced particular systemic disadvantage on the eve of the pandemic, and that will be relevant to Module 2C as well. In addition, in Module 2C, you will also have evidence from organisations who represent such groups or work on the issues which affect those groups as well. So you will have first-hand evidence about that as well. In addition to all of that, the inquiry has also instructed 2 experts for the purpose of Module 2C alone. My lady, those experts are Professor Carl O'Connor, who is a reader in public administration. He's the Research Director for Social Work and Social Policy and a co-director of the Centre for Public Administration at the Ulster University as well. Professor Anne-Marie Gray is a Professor of Social Policy at the School of Criminology, Politics and Social Policy at the Ulster University. The inquiry has sought expert evidence from them on the constitutional arrangements which provide for the government in Northern Ireland on power sharing structures and how practically these work. They've been asked to consider the arrangements which were made in Northern Ireland for responding to the pandemic and further questions relevant to Module 2C's list of issues. We've also asked Professor Gray to provide some additional evidence on the issue of health inequalities specific to Northern Ireland as existed at the outbreak of the pandemic. My lady, we anticipate that they will provide a first draft of their report by the end of December 2023. The aim is that the final version will be available in early 2024, and core participants will have an opportunity to comment on that draft prior to finalisation. My lady, it's also important and right to mention that, of course, the issue of the absence of power sharing prior to the pandemic and the impact this had is important to a number of core participants. And, of course, one of the reasons for that is because of Northern Ireland's health service and the reports that had recommended reform prior to power sharing resuming, which was, of course, at one of and the same time as the pandemic was developing. I suppose, to put it in ordinary language, whether Northern Ireland went into the pandemic 2-0 down on account of the lack of ministerial oversight of health services for the 3 years prior to the pandemic occurring. And all that I wanted to say was that a number of witnesses have been asked to address that point in their Rule 9s. Finally then, if I may turn to Every Story Matters and Commemoration and the impact film which will be shown at the hearings as well. My lady, Every Story Matters is the means by which the inquiry offers to any adult who wishes to the opportunity to provide an account to the inquiry about their experience of the pandemic. It's by this mechanism that the inquiry seeks to record and understand how the pandemic affected lives across the UK. An updated web form was made available in late May, and thousands of responses have been shared so far. The inquiry has worked alongside charities and other organisations to encourage people who wouldn't normally come forward to do so, and the inquiry will undertake further work to raise awareness of Every Story Matters in Northern Ireland from the beginning of April 2024. And I know, my lady, that you would want to ensure that people in Northern Ireland know that the inquiry wishes to hear from them. Their voices really matter. And of course, there must be many people who would rather put the pandemic behind them, given how awful it was for them. But it's so important that the inquiry records and preserves that experience and again uses it to improve any response to future pandemics. And of course, there will be people for whom the pandemic provokes great pain and who continue to grieve. But again, my lady, I know that you would want those people, particularly in Northern Ireland, to know how profoundly valued their participation would be. The inquiry has also launched a pilot programme of UK-wide Every Story Matter events. These will test different ways to enable people across the UK to speak to the inquiry about what happened in their lives during the pandemic. Some of these events are targeted towards specific groups of people affected by the pandemic, and others are open to the general public. The inquiry has already visited Belfast, of course, to speak with bereaved families, and will be holding events in 1 or 2 locations across Northern Ireland in the new year. And detail about this will be provided in the inquiry's newsletters and on the Every Story Matters events page of the inquiry's website. The inquiry team also hopes to pilot the sharing of experiences through British Sign Language in the new year, again an issue of some importance to CPs. My Lady, the hearings will commence on the 30th of April 2024 with a film about the impact that COVID-19 had in Northern Ireland. Although no decisions have yet been made about how many witnesses might be called from these organisations, the inquiry will also hear evidence on behalf of the Northern Ireland COVID Bereaved Families for Justice and Disability Action Northern Ireland as well. We hope that the film and this evidence will serve to remind everyone at the outset of the hearing the fundamental reason why this inquiry matters so much and why the cooperation of witnesses in the oral hearings is vital. And my Lady, if I may, I'll finish on the proposed meetings between the Module 2C legal team and the core participants who wish to speak to us. This will be an important opportunity for CPs to discuss lines of investigation, disclosure and the proposed witness list as well. And we encourage all core participants to meet with us. It will undoubtedly help us in our preparations. My Lady, unless I can assist you any further, may I suggest that you hear from those of my learned friends who would wish to make submissions. And I think the first you're going to hear from Northern Ireland COVID Bereaved Families for Justice first, and particularly Mr. Peter Wilcock, who represents them.
Thank you very much, Mr. Wilcock.
My Lady, as you've just been told, I represent the Northern Ireland COVID-19 Bereaved Families for Justice campaign. Your Ladyship is, we know, very aware of the importance that those whom I represent place on this module of your inquiry, particularly given the ongoing political stalemate in Northern Ireland and the fact that a Northern Irish-specific inquiry to provide scrutiny of the actions of the Stormont Assembly during the pandemic is seemingly little closer to reality than it was the last time you had a preliminary hearing in this module just under 9 months ago. As we have made clear in our written submissions, we note the indication from the inquiry that this module M2C is co-equal to M2, M2A and M2B, and that insofar as possible and appropriate, M2C will pick up issues relating to communication with the Northern Ireland Executive Civil Service, where M2 left off. Can I just start off my response by acknowledging the hard work and effort that your team have put in to ensuring that this module can start as planned in April next year, which of course is something those who I represent are particularly anxious takes place. We're also conscious of the efforts they have made to ensure the timely provision of disclosure to all core participants and their recent meetings with us, with the promise of more to come, to support our clients' engagement with the module and discuss ongoing matters before the final hearings. And we are grateful for those efforts, and they bode well for the cooperation that is to follow. We also acknowledge that in at least 2 areas the inquiry has taken into account representations that we have made in previous preliminary hearings. And thus we welcome the instruction of Professors O'Connor and Gray to provide what your counsel has described as the overarching constitutional arrangements which provides for the Government of Northern Ireland. as well as an explanation of how the power sharing structures work in theory and in practice. Could we just ask that in considering these issues and the arrangements which were made in Northern Ireland for responding to the pandemic, those experts be asked to give some explicit thought to the relationships between Belfast, Westminster and Dublin? May well be it's inherent in what we've been told, but can we just ask, in case it isn't, that some explicit thought be given to that when they produce their reports? And we note that these reports are expected, I think, by the end of January, and that Professor Gray has been asked to provide evidence setting out the health inequalities that were evident in Northern Ireland at the time of the outbreak of the pandemic, which is, as a matter your lady knows, is of utmost concern to those who I represent. And then finally, we are grateful that at least some of the issues we have previously flagged up have been acknowledged in the revised and finalised indicative list of issues. And it is ambitious, and we're grateful for that ambition. We also note that in spite of its ambition, it explicitly states that it will be kept under review to perhaps be even more ambitious in the future. And no doubt you won't be surprised that we would seek to make representations if they are required. We welcome your team's update on the wide range of Rule 9 requests that have been made, and particularly those that have been made following representations we have previously made to Robin Swan, Sue Gray and Brandon Lewis in particular. In relation to the latter, can I draw your attention to the potential for his evidence to fill the gaps in the issues that we have set out in paragraphs 6 and 7 of our written note. And my lady, it'll be a theme of my oral representations to you that I'm not going to repeat what is already in front of you in writing, simply for the sake of it, in the knowledge that I know that having drawn your attention to it, your ladyship will, of course, read that note. However, that said, those that I represent share the inquiry's concern that although we don't seek to either, one, minimise the, I think it's rightly called, vast amount of work required, or two, the efforts of those involved, or three, the practical and financial challenges presented by the lack of a functioning government in Northern Ireland, we do share your team's concern, as just expressed, that the inquiry's process is not disrupted by Rule 9 requests not being complied with as fully and expeditiously as is obviously required and should be possible. Ms Dobbin has already stated that the fact that we are the last module in this phase of the inquiry may, of course, help by giving us a little extra time. But given that individuals and departments have been on notice of what is required of them in this module for a considerable time, we urge them to provide all outstanding material as a matter of urgency so that there isn't an onslaught, as it were, of outstanding material and disclosure at the 12th hour, precluding the effective and adequate consideration that my clients are yearning for in the absence that I've previously described. And to that end, we are grateful for my learned friends' comments that they are closely, and your team is closely monitoring the compliance of the provision of witness statements with the questions actually asked and obviously required in the Rule 9 requests. My lady, for reasons of brevity only, I will not repeat them orally, but I trust you understand the possibly trenchant comments that we have already set out in paragraphs 9 and 10 of our written note. They are expressed in that way because they really do, and the inquiry, no one must underestimate the concerns of a very large number of those who I represent about the atmosphere that is created by such delay in the context of this inquiry. And the same can be said in relation to the history and the extent of the data loss that your council has outlined to us this afternoon. Our clients have similar concerns about the ongoing difficulties, to put it euphemistically, of what CTI have rightly described in a wide sense as informal means of government messaging, and the apparent factory resetting of devices linked to the former First and Deputy First Ministers, as well as a number of executive officers. We note that although CTI's note stated, and we've just been told, that the consequent report of the investigation by the Executive Office would be ready by November 2023, that date has passed and is yet to be disclosed. I'm not going to go into it in any detail. Our concern is self-evident and set out in writing, but we do repeat our observation that without prejudging the content of those investigations, it may well be insufficient, or at least insufficiently independent, to assuage the concerns of those that I represent and indeed the wider public as to how and why there was such apparently widespread deletion of material to do anything other than have an independent report. And we trust that the inquiry will actively consider whether an independent examination will be required, and that the procedure that's presently ongoing is brought to a close sufficiently far away from the inquiry not to make such an independent report impractical. And I know I need not have said it. So we understand that following the further Rule 9 requests, the inquiry has started to receive some WhatsApp material and evidence from a number of witnesses as to their use and retention of such material. But we're anxious that any investigation takes place as soon as possible. I suppose what I'm really saying is, whilst we acknowledge the efforts being put into bottoming out this issue, we trust the inquiry will be equally cognizant of the desire of our clients to have a clear idea of the extent to which such obviously potentially relevant evidence has indeed been lost. And with that in mind, I specifically draw your attention to the comments we've set out in paragraphs 12 and 13 of our written note. The inquiry will not and ought not to be reticent in reminding any recalcitrant material providers of its considerable powers of enforcement. And in any event, we trust that the inquiry's optimism that complete disclosure of the vast majority of signed statements and relevant material can be made in good time proves to be well-founded, particularly given the imminent Christmas interruptions and the need for the inquiry to review what it receives before we quite understand it can be made available to core participants. With all that in mind, may I make a suggestion? We wonder whether or not a further preliminary hearing might be appropriate, given the uncertainties on this topic, so that matters can be kept under review in the course of a hearing, and that any developments can be assessed with the most up-to-date information that is then available. But I float that in the light of what your counsel has said. And I move on to my next topic, witnesses. We note and understand that no final decisions about which witnesses will ultimately be called can be or have yet to be made. And we are grateful for the indication that any observations we may seek to make on this issue can be made, hopefully, next month. And may we take it, and as I speak, it's not altogether clear that we will, but may we take it that we may at this stage also make appropriate representations as to whether any of the expert witnesses who the inquiry has already heard of as part of Module 2, and I'm thinking particularly of Professors Henderson and Hale, might be asked to give further oral evidence, updating the evidence that was received in Module 2 during the M2C hearings. But, my lady, that is a matter we flag up at this stage, and of course can be revisited as and when it proves to be an issue. As far as the hearings are concerned, you are already aware of our continuing concerns about the number of days presently available within the listing. Nevertheless, I urge the inquiry to not use that as a reason to give full consideration to the request we make at paragraph 24 of our written submissions, that for the reasons there set out, it would be beneficial for the inquiry to call more than one witness from the Northern Ireland COVID-19 Bereaved Families for Justice campaign in Module 2C. This is a matter, I started my address to you by explaining the sensitivities of this module to those that I represent uniquely within the United Kingdom. And for the reasons I set out, we do ask you to consider that topic. In the meantime, we will continue to work hard alongside your team to be ready to start the module at the end of April next year, and we'll continue to facilitate such productive meetings which can not only help avoid misunderstandings but also help maximise the efficient use of what will be precious inquiry hearing time. You, my lady, are aware of the stance that those I represent have taken on the awarding and the of contracts for every story matters. They're set out in the written representations. I'm not going to repeat them. I will simply say that in spite of that, of course, my lady is aware that we will I'm trying to look at the phrasing that's in the written document. In terms of the impact film, we are very willing to work with the inquiry with a view to repeating the successful impact films that have been put in M1 and M2. And our members were involved in those then and will continue to be involved to the extent that they can. But, my lady, I said it was going to be half an hour. I'm not. And it really is simply because we've taken a decision that having put such material in writing, we're not going to improve on it orally. Unless there are any further matters that I can assist you with, I would simply conclude by referring you to all the points I haven't orally mentioned, which are set out in the extensive written representations that we've made.
Thank you very much indeed, Mr. Wilcott. As you know by now, I really do appreciate such a constructive and focused approach. I'm very grateful.
Thank you.
If the stenographer will forgive me, Ms. Fee, where are you? Over that way. We'll start. I think. How long roughly do you think you'll be, Ms. Fee?
5 minutes.
Oh, certainly. I don't think the microphone is. There we go.
Thank you. My lady, I appear on behalf of the Executive Office of Northern Ireland. I'm instructed by Joan McElhatton of the Departmental Solicitor's Office in Belfast. My lady, the Executive Office is one of the 9 departments within the government structure of Northern Ireland, as was determined by the Good Friday Agreement. Unlike the Cabinet Office, it has no general, central coordinating or synthesising role as regards the other 8 departments. However, in an effort to assist the inquiry, the Executive Office welcomes the opportunity to make the following observations, which are also made on behalf of 4 of those other departments who do not have core participant status in Module 2C, and that is the Departments for Communities, Justice, Education and Infrastructure. My lady, turning firstly to the Rule 9 request for statements and exhibits. Since September 22, the Executive Office team has been working hard to assist the inquiry by providing a very large volume of evidence, including corporate and individual statements and extensive documentation. The Executive Office received the Rule 9 request for its corporate statement in September 22 and submitted a first draft by the end of October 22. There followed 54 questions from the inquiry legal team in March 23, which resulted in a significant body of work to respond and incorporate into the statement, which was filed on the 2nd of October 23. 2 questions have been returned from the inquiry team in relation to the impact of the lack of an executive prior to the pandemic, and those are currently being addressed and also should be addressed in the forthcoming witness statements. Also during this period, my lady, the Executive Office were complying with their obligations as a core participant to Module 1. At the same time, the Executive Office is a core participant at Module 2 and has worked hard to digest both the oral and documentary evidence throughout. The extent of work involved in cooperating with the inquiry's modules to date has been vast for what is a very small jurisdiction with a proportionately small team. It goes without saying that, absent a government in Northern Ireland since February 2022, the conditions in which the Executive Office and all the other departments are operating in response to this significant inquiry, most notably the financial conditions, are less than ideal. In relation to Module 2C, to date, in addition to the corporate statement, the Executive Office is working to respond to the request for a further corporate statement regarding informal messaging and potential data loss, and 7 further individual statements. In addition, the Executive Office has, over the last year, provided approximately 25,000 documents to the inquiry by way of general disclosure and exhibits to statements. The Executive Office would observe that this has been a mammoth task, and in many instances the Rule 9 requests comprise of hundreds of questions, which are various and wide-ranging, including the constitutional peculiarities of Northern Ireland. The Executive Office has worked hard to facilitate witnesses with access to the information and documentation they no longer have, and that process has also been undertaken for both the former First and Deputy First Ministers, who are separately represented at this inquiry. The Departments for Communities, Infrastructure, Justice and Education have provided all discovery and statements within the agreed time periods and are now working to complete the current Rule 9 request by the 8th of January. Secondly, my lady, in relation to that informal communication, the Executive Office has received that Rule 9 request for a statement from the head of the Civil Service of Northern Ireland, and that is in relation to the informal communications and potential data loss. The head of the Civil Service had commissioned an internal Northern Irish Civil Service-wide investigation into the use of and retention or loss of data within informal messaging systems on the part of all former ministers and special advisors from all of the Northern Ireland government departments. That investigation culminated in a report which has been shared, and work is now underway within those departments to retrieve any available data from those devices. At the same time, the Executive Office is working to provide the inquiry team with all informal messaging and equivalent material in its possession. All Executive Office witnesses have addressed the matter in their witness statements. Senior civil servants from the Executive Office Department have provided 172 strands of messages to date. Following a review by the team, a small number of messages have been identified that may be in scope, and those will be uploaded in the coming days. The Departments of Education, Justice, Infrastructure and Communities have provided some messages and are continuing that process of uploading their informal communications. Thirdly, my lady, in relation to the notebooks and diaries, the Executive Office and the other departments for whom I appear today will provide all available notebooks and diaries to the inquiry. In relation to statements, in particular those from the former 2 ministers from other departments, which has been raised to your ladyship today, the matter will receive urgent action. Finally, my lady, in relation to the hearings in April 24, Modules 1 and 2 have demonstrated the vast nature of the task involved in consideration of discovery, the preparation of witnesses, marshalling statements and exhibits, digesting evidence proposals and participating fully in the hearings. The Executive Office is grateful for the regular meetings they have had with the inquiry team in furtherance of the preparation for Module 2C and appreciates the patient and collaborative approach they have shown our team, and that has been replicated in my discussions with Ms Dobbin, King's Counsel and Mr Scott. The Executive Office and the other departments for whom I speak today are determined to properly assist your inquiry and welcome you and your team to Belfast in April. Unless I can assist you any further.
No, thank you very much indeed.
Thank you.
We're very grateful. Anything further from you, Ms Dobbin?
Well, My lady, if I may, I'm of course very grateful to my learned friends for the care with which they have addressed you, and I'm grateful to my learned friend Mr Wilcock as well for raising some of those issues, which I think will probably be very useful for us to discuss in January, particularly when he has had sight of the expert report that the core participants will have will be able to comment on, and will be able to judge maybe a bit better any other issues that arise, for example, in respect of Professor Henderson's or Hale. As regards having a further hearing, my lady, I think we're confident that that will not be necessary. We're confident that we're able to keep a sufficient eye, as it were, on how things are developing. But again, those are matters about which we'll be able to we'll be able to update core participants on in January as well.
And if it becomes necessary, then obviously people can alert me.
Of course. My lady, unless I can assist you any further.
No, I'm extremely grateful again to everybody, and I really do endorse the collaborative approach and the idea of the meetings. I think it's very much the way forward when you all have such a huge task. So thank you all very much. That completes this preliminary hearing.